Hi, I'm Susan Karamanian, the Dean of the College of Law at the Hamad Bin Khalifa University in Doha. Thanks to �İ𝐴 for letting me share with you my recent work, which is reflected in an article in volume 10 of the Business and Human Rights Journal that came out in late 2025. The article is titled International Investment Agreements, Human Rights, and the Path to Net Zero. What role for corporate codes? The article is open access thanks to the support of the Qatar National Library. The article examines the role of corporate codes and policies promulgated by multinational companies, mainly in the energy sector, including those of Woodside Energy, Newmont Corporation, ExxonMobil, and Shell. What do these policies and codes say about the Paris Agreement, the path to net zero, greenhouse gas emissions, and human rights? In the article, I also make brief reference to the codes of Meta and Microsoft. I selected these codes because they're readily available. Clearly, issues related to climate change have significance to the energy sector, but also to companies like Meta and Microsoft. I'm not casting any judgment at all as to the companies and their compliance or non-compliance with the code. Instead, they were readily available on the internet, and they serve as a perfect backdrop to understand the issue that I'm focused on. And that is specifically setting out a proposed model on how a state that has obligations under the Paris Agreement, as well as under international human rights law, can fulfill those duties while dealing with a foreign investor that has made bold statements in corporate codes and policies about their commitment to addressing climate change and the environment, including the human rights dimensions of these issues. That very investor may also benefit from the protections under an international investment agreement and bring an arbitration claim against the state if the state acts to try to regulate climate change or protect human rights. So why this topic? Well, about 7 years ago, Professor Freddie Sturgis and I, and he's at Tulane, he and I were working on a possible conference on the topic under the auspices of the Center for American and International Law. We wanted to examine the role of corporate codes with an emphasis on investor-state arbitration. We weren't able to get the event off the paper, so to speak, but the topic stuck with me, and I was intrigued because going back to 2005, I remember my colleague at George Washington Law School, Sean Murphy, had written a paper on how multinational corporate codes needed to be taken to the next level. And before I was at GW Law, I practiced law for 14 years. And I know when I was litigating cases, we always wanted to know what were the relevant corporate documents? What was the company saying about its obligations and the like? An important change occurred in 2011 when the United Nations Human Rights Council endorsed the UN Guiding Principles on Business and Human Rights. The guiding principles recognize the corporate responsibility to respect human rights, which entails business enterprising having in place policies and processes to meet that responsibility. Similar language exists in various other types of international agreements or institutions. You can take a look at the OECD guidelines for multinational enterprises on responsible conduct that recognizes the importance of corporations to exercise environmental management and linking this to human rights. These soft law instruments can be argued to establish the relevant standard of care. And at least one court, the District Court of The Hague, recognized such. Mind you, the decision was reversed on appeal, but not on that specific issue. So in the paper, I look at these developments and then detailed code and policy texts. I build into the work relevant investment protection measures and principles related to them. A number of works help me frame the issues and to give important guidance, but I would encourage you to take a look at Professor Tomoko Ishikawa's book Corporate Environmental Responsibility, Investor State Dispute Settlement, The Unexhausted Potential of Current Mechanisms, that came out in 2022, Cambridge University Press. Also, Dan Esty and Nathan de Riva-Cellier had a nice article that came out in 2023 in the Colorado Law Review that focuses on how corporate climate change pledges could be a shift from soft law to hard law. So after I set the legal landscape, so to speak, I then propose a hypothetical problem using the 2012 US model BID. We have investor X from one state invests in a coal mine in another state that both states are parties to the BID, yet the host state phases out coal production. Let's assume that the investor has a code that reaffirmed its commitment to the Paris Agreement and also professes adherence to reduction of greenhouse gases, and also states it's going to comply with the code. A threshold issue, as Professor 𝐖𝐨𝐫𝐤𝐢𝐧𝐠 observed, is whether the investor's conduct is even relevant to a host state's defense. But assuming we have a claim for the violation of the minimum standard of treatment of an alien, the code text could be relevant to legitimate expectations. This is also the case if we are looking at a claim of expropriation. It'd be hard-pressed for the investor to feign ignorance of the coal phase-out of its own the coal phase-out when its own policy acknowledged a commitment to the Paris Agreement and the like. Yet what if the host state conduct is discriminatory, targeting only investor X? The dynamics could change. And this could bring into the case the role of the code in damages. If investor X had a plan that reduced greenhouse gas emissions, that could have an effect on its forecasted net cash flow, critical to determining damages in an expropriation case. Another aspect of the problem is whether the code language itself makes a statement of existing material fact, yet is later that fact is revealed to be incorrect. Does this amount to fraud by the investor, which then opens the door to the whole conversation of could the treaty be used by the investor to bring a case against the host state when the investor allegedly engaged in fraud? Finally, the code could be used to interpret substantive investment norms. Fair and equitable treatment may involve bad faith of the host state, but understanding how the state's conduct relates to the investor's commitments to, say, respecting human rights during the energy transition could help the state argue that its actions are not taken in bad faith. Finally, I'd like to just have a couple of thoughts in terms of caution. No codes are the same, okay? So the language obviously is going to help shape the legal consequences. So you have to be very careful in looking at the code language. You need to, secondly, focus on the fact, is it aspirational? Is it mandatory? Is it forward-looking? Or is it a representation of something that happened in the past? If it's forward-looking, is it conditional as well? And of course, you're all aware that international investment agreements are far from uniform. And some of the treaties recognize that host states have substantial leeway in environmental regulation. I think we will see states begin to focus on investor codes and policies like municipal courts have done. And my aim in this paper is to provide a disciplined and reasoned approach, one that is grounded in the actual code text, investment protection standards as set out in treaties, and relevant law. So feel free to reach out to me if you have any questions, but it's an exciting project and there are a lot of wonderful material out there, and I'm just happy to be able to spend some time today sharing my work with you. Thank you very much.